Good afternoon, class. Today's topic is Title 2, Incorporation and Organization of Private Corporation. In today's lecture, we will be referring to several memorandum circulars issued by the Securities and Exchange Commission. So I will expect you to browse over yung mga memorandum circulars or to at least read them in substance. Anyway, they will be part of your exams. So let's begin with the first rule in incorporation. Incorporation of private corporations is a mere privilege, meaning it is not a civil right, it is not a natural right na kailangan nating ipaglaban, but it is a mere special grant or mere special privilege na binigay sa atin ng batas. So, kailangan yung tandaan, pinagbigyan lang tayo para meron tayong para pwede tayong mag-incorporate ng corporation. So, the law which gave us the privilege to incorporate corporations or yung ating General Incorporation Law for private corporations is known as your Revised Corporation Code. Dahil sa Revised Corporation Code of the Philippines, nagkaroon tayo ng privilege or pinagbigyan tayo na mag-incorporate ng mga corporations. So, without the special act of legislature or kung wala yung General Incorporation Law, which is again your Revised Corporation Code of the Philippines, hindi pwedeng magkaroon ng corporation. So remember, it is a mere privilege. What else? Please take note of the steps in the creation of a corporation. So the first step is promotion, the second step is incorporation, and the third step is the formal organization and commencement of business operations. So anyway, we will discuss the steps, all of them. So the first step is promotion. So promotion of corporations is obviously done by, hulaan nyo, promoters. So alam naman siguro natin ang basic principle ng promotion. So pagka nagpo-promote tayo, ina-advertise natin ang isang bagay. So remember, in promotion, there is a number of business operation which is unique to the business world, by which a company is generally brought into existence. Yan. So, lahat ng activities ng mga promoters for founding and organizing yung business, ang tawag dyan ay promotion. So, please take note of a promoter. A promoter is a person alone or with others who will organize a corporation. They will procure the necessary legislation kung ito ay special corporation. They will go to the Congress and lobby na ma-approve itong legislation na to, if that is necessary, to procure necessary subscribers to the articles of incorporation. Maghanap sila ng mga incorporators, maghanap sila ng subscribers. Tapos, if the corporation is organized under the General Incorporation Law, which again is the Revised Corporation Code of the Philippines, to make sure that the documents are presented to the SEC and a certificate of incorporation is later on issued. So remember, general job ng isang promoter is to float the company. Yan ang tandaan natin. Anyway, we will learn more about promotion when we go to Title 7 of the RCCP. So the next step, class, is incorporation. So in incorporation, remember, the incorporators will come together and perform acts, condition, deeds, writings, certifications, or records and official acts which give the corporation its existence. This definition is actually not in your book. Please take note of it. I think I got this from a different author. But this is the definition. So, ang incorporator, nagsasama-sama sila. They perform acts and deeds, remember, which will give the corporation its existence. So, in short, para mas madaling maintindihan, the incorporators will execute and sign yung articles of incorporation, which will serve as the charter noong isang private corporation. And remember, upon approval of the SEC and issue sila ng certificate of incorporation, the corporation is given existence. Yun ang tandaan natin sa incorporation. Now, obviously, incorporation is done by the incorporators. So, ano ba ang mga incorporators? Stockholders or members mentioned in the articles of incorporation as originally forming and composing the corporation. So, sila yung mga original members and they will sign yung Articles of Incorporation. So, yun ang tandaan nyo. So, for this, I referred to SEC Memorandum Circular number 16, series of 2019. So, I will expect you to read also this SEC Memorandum Circular. So, this is the guidelines on the number and qualifications of incorporators under the revised corporation code. Binago kasi talaga nila ito. From the old law, sobrang ibang-iba na ang qualifications ng incorporators pagdating sa revised corporation code. So what else do you have to remember? Also, qualifications of incorporators under section 10. So in case of incorporators, remember the number of incorporators, ilan ang kailangan. Pwedeng isa lang because we have already yung one-person corporation. So what else? Pwede rin namang, in case of one-person corporation, remember class, natural person, trust, or estate may form a one-person corporation. What else? Number 2, in case of forming a domestic corporation under the RCCP, at least 2. So 2 or more persons, but not more than 15, may organize themselves and form a corporation. So yun ang kailangan nating tandaan. Pagka domestic corporation, 2 or more. In case of a one-person corporation, obviously, 1 lang siya. Kanyapin siya ay one-person corporation. So, remember, class, also that incorporators may be composed of any combination of natural persons, partnerships, corporations, associations, or even foreign corporations can become incorporators nowadays. So, bago ito, dati bawal. Dati bawal ding maging incorporator ang mga juridical persons or artificial beings like partnerships, bawal. Bawal din ang corporation na maging incorporator. Although your corporations can become stockholders in a corporation, also partnerships can become stockholders. But because of the advent of the revised code, remember na naiba na rin ang composition ng incorporators. Pwede ng natural persons, pwede na rin juridical persons. Yun ang tandaan natin sa number of incorporators. What else? If, remember, it is a natural person, kailangan meron siyang legal capacity. If it is an individual who will sign on behalf of an incorporator which is not a natural person, meaning either a partnership or either an association, a foreign corporation, or a domestic corporation. The individual signing on behalf of these juridical entities or artificial beings must be authorized by yung kanilang partnership ng kanilang corporation or association. So remember, if it refers to a natural person, so pagka nag-form ka ng corporation, contract yan. So obviously, the incorporators must have legal capacity. So in case of natural persons, must be of legal age. Again, remember, ang legal age is 18 and above. Or kung ayaw nyo gamitin yung ganon, below 18. Below 18 ay hindi pa legal age. So 18, etc. So, and obviously, they have capacity to contract. So, in case naman of incorporators, individuals signing on behalf of incorporators, not a natural person must be authorized. Number 3, there must be a stock subscription or membership in case of non-stock corporation. So, each incorporator must own or be a subscriber to at least 1 share of the stock. And in case of a non-stock corporation, yung incorporator must be a member of the non-stock corporation. So, kailangan meron siyang biniling shares. If stock corporation, if it is non-stock, must be a member of the corporation. What else? In case of citizenship, they must have the required citizenship percentage. Ito lang yung mga industries which require Filipino citizenship. Tandaan nyo kasi, hindi lahat ng corporations natin kailangan Pilipino lahat. Meron lang tayong mga certain corporations which require Filipino nationalities ng mga incorporators tsaka ng mga subscribers ay stockholders. So, tandaan nyo yan. Inclusion of foreign nationals shall be applicable to constitutional, statutory, and regulatory restrictions. Usually, we will look to the foreign investment negative list to find out what percentage yung of foreign ownership or foreign investment is allowed in a corporation. What else? Please take note also of the steps in incorporation. Name verification. So, i-verify muna ng SEC, sa SEC if the name is available to use. What else? Number 2, reserve the name if it is available. Number 3, draft and execute the articles of incorporation by the incorporators and other documents required for registration of the corporation. So, draft nyo na lahat ng kailangan. What else? Filing with the SEC. Yung certificate of reservation ng name and also the articles of incorporation and the bylaws and also a certificate of authority or favorable recommendation from the proper government agency if the corporation is vested with public interest. So, ano ba yung mga corporations vested with public interest? Banks, banking corporations, quasi-banking institutions, pre-need insurance companies, trust companies, non-stock savings and loans associations, pawn shops, other financial intermediaries. So, before these types of corporations which are vested with public interest will submit to the SEC yung kanilang articles, they should have also a favorable recommendation from the appropriate government agency. So, what else? Payment of filing and publication fees. Filing yan, hindi filing. Single L. What else? And also the issuance of the SEC of the Certificate of Incorporation. After verification and examination and all documents are found in order. So, tandaan nyo, ang isasubmit ng corporation proposing to incorporate is the Articles of Incorporation. Pagka na-approve yan, the SEC will issue a Certificate of Incorporation. Magkaiba yung dalawang yon. So, yun ang kailangan yung tandaan. What else? Remember also that in case of professionals, as a general rule, they are not allowed to organize as corporations. So, yung mga natural persons who are licensed to practice a profession cannot do so in a corporate setting. Like, for example, lawyers, they are not allowed to create a corporation for lawyers. Hindi siya allowed. Pwedeng partnership, yung GPP, yung General Professional Partnerships, but not a corporate law firm. So, hindi pwede yon. So, this is subject to exceptions. Merong mga professions which allow corporate practice. But as a general rule, yung mga professionals, they are not allowed to practice as a corporation. So, subject to exceptions provided by law. What else? Corporate term, Section 11. So, in case of corporate term, the general rule is that bago rin ito, a corporation may exist ad infinitum or perpetually. Before, it was 50 years, renewable for another 50 years. Pero ngayon, a corporation may exist perpetually. Yun na ang general rule. So, yun na ang default option. Pagka nagtayo kayo ng corporation, nag-incorporate kayo ng isang corporation, the general rule is that the existence is perpetual. Unless, remember, exception, unless the Articles of Incorporation provides for a specific period. Yan. So, kung ang nilagay nyo lang is 5 years, syempre, yung period given to the corporation is only 5 years. Yan. So, pagka nag-expire na yung 5 years na yon and there is no extension of the corporate term, the corporation will cease to exist and it will be resolved ipso facto or as a matter of fact. So, yun ang kailangan tandaan nyo. Computation of the term, corporate term, this is provided by SEC MC 21 series of 2014. guidelines governing computation of corporate term. So remember, it will include yung date of incorporation, yun ang first day niya, and the last day is the day before corresponding numbered day of the same month of incorporation in the last year of its existence. So if your term is, let us say, the articles of incorporation, sabi ang term niya is 5 years lang, and na-issue yung certificate of incorporation today. Yan. Ano bang araw ngayon? October 16. So remember, that is the first day. If the certificate is issued today, October 16, 2020, ang last day niya, remember, is October 15, 2025. So remember, the last day is the day before the corresponding numbered date. The corresponding numbered day is October 16, 2025. Pero hindi yun ang last day. The last day is the day before the corresponding numbered day of the same month of incorporation in the last year of its existence. So, 2025. So, yun ang tandaan natin sa computation ng corporate term. So, what about corporations incorporated under the old code? Ano ang kanilang term of existence? That is answered by, remember, SEC Memorandum Circular Number 22, Series of 2020, Guidelines on Corporate Term, enacted August 18, 2020. So, bago lang ito, bagong-bago, mainit-init pa. The general rule in case of corporations already incorporated under the old code is that even without doing anything, ang kanilang term ay magiging perpetual. So, tandaan nyo yun, if they do not act on the term, kahit na mayroong nakasulat na limit ng term doon sa kanilang articles of incorporation, magiging perpetual term din ito according to yung SECMC na yan. Now, again, the exception is, that is a general rule, the exception is in case a corporation intends to retain yung kanilang original term as provided for in the articles of incorporation. So, if the original term of a corporation is 5 years, it was incorporated under the old corporation code. Remember, if they want to retain yung 5 years, they have to file, approve actually a resolution. The resolution will state that they want to retain the existing corporate term. The resolution must be approved by the majority of the board of directors or trustees, and also majority vote of the stockholder representing the majority of the outstanding capital stock, including non-voting shares, or a majority of members in case of non-stock corporation. So if they want to retain yung kanilang term as originally indicated in the articles of incorporation, and this corporation was incorporated under the old law, mag-approve muna sila ng resolution. Majority BOD, majority OCS, including non-voting shares, and also majority members. And then they have to submit to the SEC notice yan with attached director's certificate signifying yung kanilang intention to retain yung kanilang specific corporate term as already provided in the articles of incorporation. So they will submit it to the SEC, and the SEC will issue a certificate of filing notice to retain specific corporate term. So certificate of filing notice to retain specific corporate term. Yun ang i-issue ng SEC to the corporation. Now, remember, if they want to retain their specific corporate term as provided for in the articles of incorporation, they should file this notice until February 23, 2021 in accordance with Section 185 of the RCCP. So, yun ang kailangan yung tandaan. Any corporation which failed to file yung ganitong notice to retain yung kanilang original term will be deemed perpetually existing. So, mapapalitan ng perpetual lahat. Kung wala kang ginawa, perpetual. So, yun ang kailangan yung tandaan. If you do not do anything within the next 2 years, counted from February 23, 2019 or the enactment of the Revised Corporation Code, magiging perpetual din yung term. So, if you want to retain your old term, kailangan ng positive action from the corporation to file a notice. What else? Also, obviously, you can extend or shorten corporate term in case a specific period is provided for. O, pwedeng extend yan, pwedeng i-shorten yan. Tapos, kung yung term nyo ay perpetual, di ba? Kung malamang hindi nyo na kailangang i-extend yan. Pero pwede nyo i-shorten if you want to dissolve earlier. Also, if your term is specific, pwede nyo i-shorten pa yan. Pwede nyo rin namang i-extend. What else? Wala namang limit ang number of extensions in case nagbago yung isip ninyo. If a stockholder is not interested, again, in the extension of corporate term, pwede niyang i-exercise yung kanyang appraisal right as I've already introduced in Title 1. Anyway, we will study that later on. Please take note also na pwedeng i-revive ang mga expired corporations. So, there are steps to revive yung mga expired corporations as provided for in SEC Memorandum Circular number 23, series of 2019. So these are the guidelines on the revival of expired corporations. We will discuss that when we meet on Saturday. So ito ang very important to read from as your assignment. SEC Memorandum Circular number 23, series of 2019, the guidelines on the revival of expired corporation. So, yun ang tandaan natin when it comes to corporate term. Now, Section 12 talks about the capital stock requirement of a corporation. You will learn in Section 12 that there is no minimum authorized capital stock for corporations except if there is a special law which provides otherwise. So remember, yung authorized capital stock is determined by the incorporator. Silang nagsasabi. So ano ang kapital na kailangan natin para sa ating business? So yun ang authorized capital stock. So ang authorized capital stock, magkakaroon lang kayo niyan if the shares you are issuing are par value shares. Now if you are issuing no par value shares, remember, capital stock meron kayo, but not authorized capital stock. Authorized capital stock is available only, meron lang yan kung tayo ay nag-issue ng par value shares. Now, since the authorized capital stock is determined by the incorporators, ano ang basis nila? Ito yung amount sufficient to run a business. Yan. So, yun ang authorized capital stock. So, let us say magtatayo ako ng business. Gusto kong magtayo ng food cart. Yan, na pwedeng i-franchise ng mga kung sino-sino. So, yung food cart na yan, let us say, para sa food cart, ang meron akong kasama, 5 kami. O sige, 2 na lang kami para hindi ako mahirapan. O sige, 3 na lang. 3 na lang kami para hindi ako mahirapan. So, 3 kaming nag-incorporate ng isang corporation. Ang aming authorized capital stock, malaki-laki ng konti. But remember, this is more than sufficient to run a business. Let us say our authorized capital stock is para sa food cart, I think 300,000 is sufficient as authorized capital stock. So we will issue obviously par value shares. So yung authorized capital stock namin na 300,000 pesos, napag-usapan namin that we will divide it into 1,000 shares. So ang authorized capital stock namin na 300,000 divided into 1,000 shares, ang par value ng bawat share ay 300 pesos per share. Now, dun sa authorized capital stock na yan, bumili ako ng 100 shares or equivalent to 100,000 pesos. Yun ang aking investment as a stockholder. Now, yung ibang kasama kong incorporators, they also invested and they bought, let us say, 50 shares of stock. So, isang 50 units or 50 shares of stock, ang kanilang investment is 50,000 pesos. Yung isa kong pagkasama, di ba, 3 kami, ganun din ang kanyang investment, 50,000 pesos or 50 shares of stock. So, meron kaming unissued shares. Ang kanyang halaga is 100,000 worth value or of unissued shares or 100 shares na pwede naming ibenta sa ibang mga gustong maging stockholder ng aming corporation. Anyway, remember, as long as the amount is sufficient to run a business, yun ang determination ng authorized capital stock. Yan. So anyway, what you have to remember about Section 12 is that special laws may require a higher paid-up capital. So yung paid-up capital is that portion of your subscription na binayaran mo na. So kung halimbawa ako ang aking subscription is 100,000 pesos, binayaran ko yung kalahati, the paid-up capital na binayaran ko is 50,000. Yun ang paid-up. Yung mga kasama ko, ang binayaran nila is 25,000. So ang aming paid-up capital total is 100,000 paid-up capital. So, yun ang kailangan natin tandaan sa paid-up capital. Special laws, in case of special corporation or corporations covered by special laws, they can require a higher paid-up capital. But later on, you will learn that special laws may also require a minimum authorized capital stock. May mga corporations na mayroong required ang law na minimum authorized capital stock. Now, in relation to Section 12, please take note of the foreign investment negative list. So, the foreign investment negative list defines the Filipino ownership requirement regarding corporate capital. Yan. So, the latest foreign investment negative list is the 11th. So, 11th regular foreign investment negative list under Executive Order number 65, November 16, 2018. Please check it out. Kailangan yung tignan ito dahil minsan tinatanong ito sa board exam. So, makikita nyo dito, no foreign equity, mass media. So, ABS, dapat wala siyang foreign equity. Naging issue yan. What else? In case of practice of professions, bawal ang foreign equity, etc. Up to 25% foreign equity is allowed in case of recruitment for overseas employment. Yan. Up to 40% foreign equity. Contracts for constructions and repair, etc. Public works. Anyway, check yung foreign investment negative list. Please check yung 11th, that is the latest. So, meron tayong mga industry na hindi allowed ang foreign investment. Merong industry allowed up to 25%. Merong industry allowed up to 30%. And merong industry allowed up to 40% foreign equity. It's all there. So, dalawang list yan. List A and also List B. List B will refer to foreign ownership limitations because of reasons of security, defense, risk to health, and morals, and for the protection of SMSEs, small and medium scale enterprises. So, pagka-manufacture ng mga barrel, ganyan, up to 40% foreign equity only. So, tingnan nyo yung list. Madami, as in talagang mahaba yung list. List talaga siya. So, also, you have to consider for special laws. Ito rin ay isang list. Yung minimum paid-up capital requirement based on special laws. Merong list yan sa SEC. All of these list at saka yung mga materials are found in the internet class. So, dito sa minimum paid-up capital requirement list based on special laws, naka-enumerate dyan yung mga industry na meron siyang minimum paid-up capital. So, paid-up ang minimum. I will give you an example in case of yung madali na maintindihan natin. In case of ba't wala akong makitang madali? Nakakainis naman. So, in case of ba't nawawala? Insurance, sabi na lang natin insurance. So, kung halimbawa ang insurance mo is meron kang life insurance company, walang minimum authorized capital stock, remember, but there is a minimum paid up capital. The minimum paid up capital is 1 billion for a life insurance company. For mga lending company, remember, if it is in a first class city, 300,000 is the minimum paid up. Other classes of cities, 150, municipalities, 75. Pawn shops pala, ito pawn shops. So pawn shops, ang kanyang minimum paid up capital is 100,000. So kung ang iyong authorized capital stock ay 100,000 lamang, to put up pawn shop, obviously, dapat yung authorized capital stock mo fully subscribed yan and fully paid up. Kasi nga, ang minimum paid up na required by law is 100,000. So, let us say, ang authorized capital stock mo is, sa pawn shop 100,000. Ang barat, no? So, anyway, dinivide mo yan sa, let us say, 1,000 shares. So, bawat isang share mo is 100. So, 100,000 authorized capital stock divided into 1,000 shares, par value of 100 per share. Now, remember, dahil nga ang require ng law na minimum na paid up is 100,000, dapat yung 1,000 shares mo na yan, amounting to 100,000 at 100 par value, dapat lahat yan napasubscribe mo or naibenta mo lahat. Now, also remember na dapat yung mga 1,000 shares na yan ay napabayad mo lahat. All of them should be paid up so that you can get the minimum paid up capital required by special laws when it comes to pawn shops. Now, interesting here is sa list na ito is yung mining corporations. In mining corporations, there is a minimum authorized capital stock. It is, remember, 100 billion pesos. And there is a minimum paid up capital stock, 6,250,000. So, bago ka magtayo ng isang mining corporation, dapat ang minimum mo authorized. Anyway, hindi naman required na paid up lahat yan. E di, basta yun ang i-declare mong authorized. Tapos maghanap ka na lang ng mga ibang stockholders later on. Ang minimum lang naman na gusto ng law na paid up mo, na nabayaran is 6,250,000 worth ng iyong authorized capital stock should be paid up. So, yun ang tandaan natin. Please look for the list sa inyong sa internet. Google nyo. Bata pa naman kayo. Kayang-kaya nyo na yan. So, anyway, please take note also of the definition of articles of incorporation. This is in relation to section 13 and 14. Now, if you notice in your book, meron dyan section 13. Kasi 'di ba, I'm sure ginagamit niyo yung old book, yung book ninyo with the old law. Probably is a new book, but ang nakalagay dyan is the old law. Wala akong mai-recommend na book for revised corporation code kasi hindi maganda lahat. Swear. Seryoso ako. Nabasa ko na yung mga lumabas. Hindi talaga. Para kayong nagsayang ng pera. So, pagtiyagan na lang natin yung matrix na pinahanap ko sa inyo. So, yung section 13 sa old corporation code obviously is no longer applicable. It has been repealed. Tapos, inusog nila yung mga ibang provisions. So, anyway, articles of incorporation, please make note of the definition. Document prepared by the persons establishing a corporation and filed with the SEC, containing the matters required by the revised corporation code under sections 13, and yung format niya is section 14. So in sections 13 and 14, these are the contents and form of the articles of incorporation. The form is found in section 14. Tignan nyo na lang. Yan ang form. So the contents are number 1, name of the corporation. Remember, class, the name of the corporation is also discussed in under section 17, section 18 before. Now, what you have to remember about corporate name is that a corporation will acquire juridical personality under the name stated in the certificate of incorporation. So, importante ang pangalan para sa isang corporation. Now, the rules regarding the use of corporate name, we will discuss during class. Please, for that purpose, please read SEC Memorandum Circular Number 13, Series of 2019, the amended guidelines and procedures on the use of corporate and partnership names, June 21, 2019. Binasa nyo na ito actually sa partnerships. So, we will discuss this more on Saturday. So, basahin nyo uli yung memorandum circular. Anyway, kasama ito sa inyong exam, at least with respect to names of partnerships. So, makakatulong ito para sa inyong midterms. So, basta ang kailangan, tandaan, each corporation must have a name by which it will sue and it is to be sued. And also, a name to distinguish it from other entities. Yan, kailangan may pangalan. So, ang tao nga may pangalan, corporation pa kaya. So, aso nga may pangalan corporation pa kaya. So, anyway, ang pangalan ng dog ko? Hindi nyo alam? Sige. What else? Purposes of a corporation. So, remember, ang corporation will define the powers. Purpose will define the powers of the corporation. It will define the powers and also limit the powers. Any act beyond the power is known as ultra vires act. Any act within the powers, intra vires. So, yun ang tandaan natin. So, what are the rules regarding purpose? The purpose must be lawful. Obvious naman yan. Pagka meron kayong illegal purpose, it may be a ground for rejection of your articles of incorporation. Number 2, the purpose must be stated with sufficient clarity. So, dapat sa purpose clause ninyo, kasi makikita nyo sa articles of incorporation, yung sa format, merong purpose clause dyan. So, ilalagay nyo kung anong purpose ng corporation. Dapat, pagka naglagay kayo ng purpose ng corporation, maliwanag kung ano talaga ang business ng corporation. Hindi pwedeng purpose yung to earn profit. Anong klaseng corporation siya nun? Pagka ang purpose niya is to earn profit, malamang it is a profit-making corporation. But what kind of business? Yun ang tanong dyan. If you cannot sufficiently determine what kind of business a corporation will enter into by a mere reading of the purpose, hindi maganda ang pagkakastate mo ng purpose. What else do you have to know about purpose, yung purpose clause? So remember, yung primary purpose must be stated, and remember, main purpose specified. So clear yan. Pwede naman kasing magkaroon ng maraming purposes ang isang corporation as long as you specify kung ano ang primary purpose at kung ano yung mga secondary purposes ng corporation. So, specify nyo, this is the primary purpose, this is the secondary purpose, walang problema yan. Now, if you have also several purposes like let us say, ang purpose ng corporation mo is they provide construction services and also consultancy services. Let us say, ang pangalan ng corporation, ang primary purpose mo sa dalawang yun is yung construction service. So, dapat ang pangalan ng iyong corporation, let us say, Global Construction and Consultancy Services Incorporated. So, yun ang pangalan ng corporation mo. Unahin mo kung ano yung primary purpose mo. Since the primary purpose here is construction purpose, yun ang inuna ko, Global Construction and Consultancy Services Incorporated. So, if your primary purpose is for consultancy, remember, unahin mo yung consultancy, Global Consultancy and Construction Services Inc. So, yun ang kailangan yung tandaan sa name ng sa purpose ng corporation in relation to its name. What else? Also, remember that the purposes must be lawfully combined. So, hindi siya kailangan na related to one another. Hindi sobrang kailangan na magkakakonect sila. But they must be able to be lawfully combined with one another. What else? Please take note also, you have to indicate the principal office of the corporation. So, the place of the principal office of the corporation is where the books are kept and the records are ordinarily kept, where the officers will meet and for the purpose of managing affairs and transacting business of the corporation. So remember, the place of where the principal office of the corporation must be within the Philippines. So according to SEC Memorandum Circular Number 6, Series of 2016, the Omnibus Guidelines on Principal Office Address, address of each incorporator, director, trustee, or partner, the address must be very specific. So remember, kailangan sa address ng corporation, it should include, if possible or feasible ang ginamit na term ng law, the street number, street name, barangay, city, or municipality, if applicable, the name of the building, number of the building, name or number of the room or unit. So very, very specific also. So also in relation to the same circular, change in address, kailangan if the move is from the same city or municipality, from San Vicente, lilipat sila ng San Miguel, the corporation is not required to amend its articles of incorporation. Pero kailangan i-declare niya yung kanyang bagong address sa general information sheet. Although if they want to so amend, pwede naman. If the change of address is from a new city, from a different city or municipality, is to a different city or municipality, let us say from Tarlac City, lumipat siya ng Cabanatuan, Nueva Ecija. Remember class that there is a necessity to amend the articles of incorporation to indicate the new location within 15 days from transfer to said location. What else? So corporate term we already discussed under section 11. Also the incorporating directors or trustees. So remember, names, nationalities, and residences must be specified. Again, the address must be very specific. Again, SEC Memorandum Circular Number 6, Series of 2016. Also, the number of incorporating directors must not be more than 15. In case of trustees, it may be more than 15. So, usually yung mga incorporating directors or trustees, they are intended to be replaced dun sa first regularly scheduled meeting ng corporation. So, sa unang regular meeting nila or yung annual meeting nila, they will replace yung mga incorporating directors or trustee. Tapos, ang term of office is 1 year. In case of trustees, 3 years. Anyway, we will discuss that more when we go to Title 3, Board of Directors, and the title on non-stock corporations. If I'm not mistaken, Title 10. Yan. So, anyway, capital stock or capital and subscribers or contributors. So, remember yung capital stock mo, these are the necessary provisions in stock corporation. Amount of authorized capital stock, I've already discussed kung anong authorized capital stock. Number of shares into which it is divided, all determined by the incorporators. Par value, obviously, yung authorized capital stock nyo, i-divide nyo lang sa number of shares, makukuha nyo yung par value ng each shares. Names, nationalities, residences of the original subscribers. Again, the residences must be very specific. Amount of subscription and the amount paid up by each of the subscriber on his subscription. So, ilalagay nyo kung magkano ang binili, ilang shares yon, at saka kung magkano ang ibinayad dun sa kanyang total subscription. So, let us say the subscription is 100,000, equivalent to 100 shares, tapos ang paid up niya is 50,000. So, yun ang ilalagay mo dun. And what else? If some or all of the shares are without par value, such fact must be stated. So, usually pagka no par value shares, ang ilalagay lang is the number of shares subscribed, yun. Name, number of shares subscribed, yun ang nilalagay pagka no par value ang binili. What else? Necessary provisions in non-stock corporations, amount of capital or money contributed or donated by specified persons. Again, non-stock corporations, may pera yan kasi may donations. What else? Names, nationality, residences of donors or contributors, and respective amount contributed by each. So, yun ang kailangan yung tandaan. What else? For nationalized corporations, kailangan merong provision dyan na transfer of stock or interest which will reduce the ownership of Filipino citizens to less than the required percentage of the capital stock as provided by existing laws. There should be a restriction, or there must be a provision providing such restriction in the articles of incorporation. So, yun ang tandaan natin sa contents ng articles. For form, please take a look at section 14 of the RCCP. What else? Acquisition of juridical personality as found in section 18, section 19 before sa inyong book. So, medyo nag-skip tayo kasi ito yung mga connected na provision. So, remember, section 18 talks about the registration, incorporation, or commencement of juridical personality. So, tandaan nyo na acquisition of juridical personality will start with the issuance of the certificate of incorporation. So, magkakaroon lang naman ng juridical personality separate and distinct from the stockholders or members yung corporation if the SEC issues to the incorporators a certificate of incorporation under its official seal. The corporation is now a de jure corporation. So, yun ang kailangan yung tandaan. What else? So, blah, blah, blah. Certificate of incorporation, ito yung important part. Not only gives juridical personality to the corporation, but places it under the jurisdiction of the SEC. So, yung kanyang certificate of incorporation together with the articles and the bylaws, they will constitute the corporate charter or corporate franchise. Yan. Yan ang kailangan nating tandaan sa part na yan. What else? Yun. Anyway, pagka nagkaroon na ng buhay ang corporation, dahil nga meron na siyang certificate of incorporation, iba pa rin yung formal organization and commencement of business transaction. So, remember, it has 5 years from the date of incorporation to begin yung kanyang to formally organize and to commence the transaction of the business of the corporation, or else it shall be deemed dissolved. Yan. What else? In case of religious corporations, remember, this is an exception. The RCCP does not require the SEC to issue a certificate of incorporation. Under Section 110, basta nag-file na ng articles of incorporation, corporation sole na ang isang religious corporation. What else? Registration when it comes to cooperatives. I really hope we can discuss cooperatives because this is a part of the course outline. But anyway, ang haba kasi So, class, cooperative will acquire juridical personality upon registration with the Cooperatives Development Authority. So, anyway, hindi na kailangang i-register sa SEC yan. For cooperatives, iba yung pinagre-registeran nila. So, how about the formal organization of business operations? So, remember, yung formal organization and commencement of business operations, it is, remember, the process of structuring the corporation so that it can carry out yung purposes or yung business for which it has been incorporated. So, remember, class, pagka meron ng certificate of incorporation, meron ng legal existence or juridical personality of meron ng juridical personality yung corporation. But remember, formal organization will bring the corporation to life. There is legal existence, but as yet, there is no life until yung meron ng formal organization. So, bahala na sila kung paano nangyari yon. But anyway, remember yung formal organization, acts which constitute yung formal organization ng business is yung adoption ng bylaws if it is not yet adopted at the start. Hindi kasabay na sinabit ng articles, pwede namang mahuli. What else? Pagka nag-adopt na sila ng bylaws and files the same with the SEC, they elect yung members ng board of directors or yung trustees. What else? They elect also officers. They establish yung principal office, they provide for subscription and payment of the capital stock, and other steps which will enable the corporation to transact legitimate business. So, kumbaga yung mga preparatory steps para makapag-transact sila ng business and to accomplish the purpose for which it was incorporated. Now, in case naman of commencement of business, very specific na to. Ito yung mga entering into contracts for the negotiation or lease of yung properties which will be used for the business, or yung construction ng mga factory, and taking step to expedite yung construction ng mga equipment, pag-order ng equipment, etc. etc. These are acts to commence yung business ng isang corporation. So what is the effect now if there is a failure to use a corporate charter and there is continuous in operation of the corporation? Under Section 21, remember, it provides that in case the corporation fails to formally organize or commence its business within 5 years from the date of incorporation, the certificate of incorporation shall be deemed revoked the day following yung end ng 5-year period. So, pagkatapos ng 5 years, yung susunod na araw, the certificate is revoked. What else? In case naman of continuous in operation for a period of at least 5 consecutive or sunod-sunod na taon, the SEC may after due notice and hearing, place the corporation under delinquent status. So remember, may hearing pa to, mayroon pang notice. So if the corporation will be placed under delinquent status, it depends on the SEC. So remember, a delinquent corporation shall have a period of 2 years to resume operations and will comply with the requirements prescribed by the SEC. So, remember, a failure to comply with the requirements and resume operation within 2 years shall cause the revocation of the corporation certificate of incorporation. So, remember, kailangan mag-resume siya within in a period of 2 years and comply with all the requirements of the SEC. Pagka na-comply nila yan, SEC shall issue an order lifting yung delinquent status ng isang delinquent corporation. Now, remember also that the revocation will be effective immediately. So, once an order of revocation is issued, the corporation's existence is terminated unless yung order of revocation is lifted. So, remember, pagka-revoke na ang certificate of incorporation ng isang corporation, hindi na siya pwedeng mag-operate ng business. It cannot issue shares. Ang pwede na lang niyang gawin is to liquidate the assets. Pwedeng mag-sue to recover yung kanyang property. What else? Order of revocation may be lifted. It will restore the corporation into its original status as if it was not. At least there is no revocation order against it. So, what else? Let's see. Notice to appropriate regulatory agency. So, for corporations na na-revoke or na-suspend ang certificate of registration, SEC shall give notice to the appropriate regulatory agency. So, the requisites to amend the articles of incorporation are found under Section 15. Remember, the first one is that the amendment must not be contrary to law and must be for a lawful purpose. Number 2, approved by majority vote of the BOD or BOT and 2/3 vote or written assent of the OCS or the members in case of non-stock corporations. Number 3, original and amended articles will be submitted and will contain all provisions required by law to be set out in the articles of incorporation. So, yung mga changes made should be underscored. I-highlight ninyo, i-bold ninyo, i-underline ninyo yung mga changes or change na ginawa nyo dun sa articles of incorporation. So, submit the original, submit also the amended with underscoring of the changes made. What else? Certification under oath by the corporate secretary and majority of the directors or trustees stating the fact that the amendments have been approved by the required votes of the stockholders and or members. So remember, 2/3 OCS, 2/3 members. And remember, certification will be submitted to the SEC. So, amendment shall take effect only upon the approval of the SEC. And if there is failure to approve by the SEC, if not acted upon, meron tayong automatic approval provision. So, yung automatic approval provision, 6 months from the date of filing, if not acted upon by the SEC for causes not attributable to the corporation. Kompleto ang requirements, tapos kompleto ang requirements for amendment, the SEC did not act upon it. So, if not acted within 6 months from the date of filing, it is automatically approved. Ito yung automatic approval provision ng SEC. But this does not apply in all cases. Meron tayong mga cases that bawal itong 6 months automatic approval rule na to. What else? If the corporation is vested with public interest, the amendment must be accompanied by a favorable recommendation from the appropriate government agency that the amendments are in accordance with law. What else do you have to remember about the requisites? Yung mga portions ng articles which with established or accomplished fact, hindi na kailangang i-amend yan. Ano yung mga established fact? Names of the first directors or trustees, names of incorporators, hindi na pwedeng palitan yan because yun nga, they established an accomplished fact. Yan. What else? In case of foreign corporations, they are not required to amend here in the Philippines. They are only required to submit a copy of their amended articles of incorporation or bylaws within 60 days after it becomes effective. Remember, ang mga amendment ng foreign corporation, ginagawa nila yan sa kanilang home country. But the foreign corporation should give a copy to the SEC within 60 days from amendment. Yan. What else? A disapproval of the articles of incorporation. So, disapproval of the articles of incorporation or any amendment thereto is governed by Section 16. So, if the articles are not substantially in the form prescribed, so remember, substantial compliance lang naman ang required sa form as found in Section 14. If you do not substantially comply with it, the SEC may reject your articles or any amendment thereto. Purposes are illegal, obvious naman to, they will reject. Certification concerning the amount of capital stock or subscribed capital or paid up is false. Obviously, the SEC will reject yung articles na yan or any amendment. Requires a percentage of Philippine ownership of capital stock under existing laws or special laws or the Constitution has not been complied with. What else? In PD 902, yung SEC Reorganization Act, this is already incorporated in the new code. So, sa revised corporation code, in-incorporate na nila ito. So, anyway, you add this to the list. Fraud in procuring the certificate of incorporation. Example naman. Serious misrepresentation. What else? Refusal to comply with an order of the SEC. What else? Continues in operation for at least 5 years. So, now you know that this is consecutive, five consecutive years. Failure to file bylaws, failure to file reports, and that's it. Now, how about de facto corporations? De facto corporations are ano ba yan? Covered by section ano bang section ng 16? Hindi. De facto corporations covered by Section 19, yan, de facto corporation. So, two kinds of corporations as to their legal right to corporate existence, de jure and de facto. So, obviously, a de jure corporation complied with all the requisites of law. So, strict or substantial compliance for incorporation. So, remember, pagka ang corporation is de jure, it cannot be attacked collaterally or directly by the state. So, hindi mo pwedeng i-attack ang existence ng isang de jure corporation, either directly or collaterally. So, yung mga terms na yun, nasa book ninyo, basahin nyo na yan. What else? De facto corporations under Section 19, nandito pala yun. So, a corporation which actually exists for all practical purposes as a corporation. But remember, as against the state, hindi siya considered as a corporation. So, in case of de facto corporation, it tried to comply with all the requirements to become a de jure corporation. Pero, remember class na meron siyang failure, merong defect. So, it did not comply sufficiently to be accorded status of a corporation even as against the state. Sinubukan nila talaga pero meron silang failure at some point. So, remember the requisites of a de facto corporation. Number 1, a valid law which a corporation with powers assumed might be incorporated. So, para maging de facto corporation, kailangan meron kang pinag-incorporatean na law, in which case this is your revised corporation code of the Philippines. Number 2, there must be a bona fide or bona fide attempt to organize or a corporation under the said law. So remember class, there must be a colorable compliance with the statute. Hindi naman kailangan ng substantial, pagka kasi substantial compliance na, de jure corporation na siya. So kailangan there is a bona fide attempt. If bona fide kasi is Latin pagka English binona fide mo, no? So there is an pagkakaroon ng attempt in good faith, yun na lang para magkasundo tayo. Attempt in good faith to incorporate if nag-file sila ng articles of incorporation. So usually class, ang mga de facto corporations, actually meron silang certificate of incorporation, except that somewhere in the registration there is a defect which will make them de facto. So, for all purposes, even including third persons, they are considered a corporation. Pero pagka gobyerno na, state na ang kausap, they are considered only as de facto corporation. So, yung kanilang status is not sufficient for them to be considered as a de jure corporation in the eyes of the law. But for purposes of third persons, okay, walang problema, considered as a corporation. Number 3, requisite, there is actual user or exercise in good faith of corporate powers. They act as a corporation. So, yun ang kailangang tandaan sa requisites ng isang de facto corporation. Please take note also of co-warranto proceedings. So, remember, ang co-warranto proceeding is an action for usurpation of a public office, position, or franchise, and it is brought or commenced by the Solicitor General by filing a verified petition in the name of the Republic of the Philippines against an association which acts as a corporation within the Philippines without being legally incorporated or without lawful authority to so act. So remember, ang co-warranto proceeding is used to question yung personality ng isang corporation. So, ang kailangan tandaan natin sa isang co-warranto proceeding, this is the direct proceeding to question corporate personality. So, ang pwede lang filean ng co-warranto proceeding is a de facto corporation. So, pagka de jure ka, even the state cannot file any action to question your personality kasi nga ikaw ay de jure, not even a direct proceeding. In case of de facto corporations, the proper action to question whether or not you are entitled to exercise powers of a corporation or you are entitled to the franchise given to the corporation, the direct proceeding is yung co-warranto. So, yun ang direct attack. So, Solicitor General files it. What else? Please take note also yung collateral attack. Yung collateral attack sa personality ng isang corporation is meron kang case which is filed already. And then in that case, which is obviously not co-warranto because yung direct proceeding is yun yung co-warranto. In that case, which you filed, you question the legal personality of the corporation. So, bawal yan, collateral attack. let us say sinisingil ka ng isang corporation ng utang mo, tapos alam mo there's a defect in the incorporation nung corporation na naniningil sa'yo. So in your defense, you question the personality of the corporation. That is a collateral attack. So remember class, bawal yan. So incidental proceeding yan. Ang proceeding lang by which you can question the status of a de facto corporation is a direct attack by a warranto proceeding. And remember, only the government through the Solicitor General can question the personality of a de facto corporation. What else? Please take note also of your corporation by estoppel, much like partnership by estoppel. So, founded again on the principles of equity designed to prevent injustice, for the protection of third persons. So, persons who assume to form a corporation and exercise corporate functions and enter into business relations with third persons. To protect yung third persons with whom they enter into business relationship, yung law, dinesign nila yung corporation by estoppel. So, all persons who assume to act as a corporation, and even though they are not authorized to do so, will be liable as general partners with all of their property, personal properties, for all debts, liabilities, and damage arising as a result thereof. So, pagka ikaw ay nagpanggap na corporation, remember, ang liability mo, general partner. So, anong pinagkaiba ng estoppel at saka de facto? In de facto, remember, there's colorable title. There is an intent to incorporate. In corporations by estoppel, basta na lang kayong nagpanggap na isa kayong corporation. In fact, in de facto, there's even issued to them a certificate of incorporation. But somehow, yung kanilang registration or incorporation is defective. In corporation by estoppel, there's actually no effort to comply with the legal requirements. So anyway, that's it for Title 2 of the Revised Corporation Code. I will see you class tomorrow. Please read yung mga memorandum circulars that I have referred to. We will discuss them tomorrow. Thank you class, and good afternoon.